Audio stream check. Audio stream check. Yes, Kayla, I can hear you.
Okay, great.
Thanks.
Yep,
I see John joined us too. So yeah, we got a few more people online now. I just wanted to, the judge was asking me. We only saw myself and Emily, so
sure, no
maybe some
problem.
late joiners, I guess.
Yes, yes.
Okay, thanks.
Yep.
It's 10 o'clock and we can go ahead and get started. So let's go on the record. The commission has set this time for a rule comment hearing in files captioned file number OX-2024-0255 in the matter of the amendment of the commission's rule regarding stipulations and agreements, and file number OX-2024-0256 in the matter of the amendment of the commission's rule regarding intervention. My name is Nancy Dippell. I'm the regulatory law judge presiding today. I also have with me Chair Hahn and Commissioner Mitchell online. I expect the other commissioners will be joining us soon. Since this is a rulemaking hearing, it's not the same kind of procedures that we usually have in our commission hearings. It's just to take comments on the rule in opposition or support. And and anyone is allowed to comment. I will ask people to come up to the podium to speak or to speak into a microphone. And I will ask you to identify yourself and spell your name for the court reporter before you give comments. All of the comments will be taken down and transcribed, and then the commission will proceed with those comments through the regular rulemaking process, eventually with an order of rulemaking to be filed with the Secretary of State. Do I have any questions before we get started?
Your Honor, this is Tim Opitz for MECG. There are two separate cases when we make our comments. Do you want us to make them one, sit down, come back up for the other and sit down, or just make all of our comments at the same time?
I think it'll be fine to make both of your comments at the same time, but if you could make your comments for one rule and identify which rule, and then for the other rule and identify those, that'll be fine. We can, as long as we can keep them identifying which rule is being commented on. But since these are fairly simple rules, I don't think it'll be a problem to give all your comments in what time.
Okay, thank you for that clarification.
Thank you. Any other questions before we begin? Okay. Our rule usually states that we begin with comments in support of the rule and then comments opposing. If you have both kinds of comments, maybe you support one rule, maybe you oppose the other, you can give those at the same time also. So I'm going to begin just asking if I'm trying to figure out, we have some people online that are going to want to testify. We have some people obviously here in the hearing room. I'm going to allow staff to go last. But maybe I could begin with public counsel. Would that, Mr. Kleiser, would public counsel be willing to start us off?
Did you want to stick with the comments in support going first?
I do. If you don't have any comments in support, then we can come back to you.
I think it would be more fairly accurate to reflect our comments as not in support, although that want to qualify that a little bit, so I'm going to hold off for now.
All right. Mr. Kaufman, would you like to go next?
I have a mixture of comments in support and issues of concern. I probably have more issues of concern, but if you'd like me to start off with some comments, I suppose I could do that. If I take this opportunity to make comments, will I have an opportunity to respond later to things that are brought up?
I suspect I will allow responses.
Okay,
They don't get too wordy.
okay,
Could you, I get you to go ahead and come up to the podium?
sure.
Go ahead, and if you could state your name
Sure.
and who you represent and spell it for the,
Sure. John B. Kaufman, I'm appearing on behalf of the Consumers Council of Missouri. Would you like an address or anything of that nature? Okay, I think the court reporter probably has that. The Consumers Council is generally supportive of the rules that have been proposed by the commission. The changes do not seem to be of a nature that would change much of the way that we engage in cases, at least as far as they are. And let me just start with the intervention rule, which is the 0256 case, the rule on interventions. Merely stating the reason for intervention is entirely reasonable, as well as explaining whatever position statement might be available at the time that the petition for intervention is filed, as well as an explanation for why a position could not be asserted. And I think what I would hope that the commission would keep in mind is that a lot of information is held by utilities, and we don't have that. And so we have to intervene in order to do discovery, to find out the information. There are a couple of cases right now where much of the most crucial information is designated as highly confidential. And so that puts us in a position where we need to intervene to find out, more, substantively what's going on and what our position is. As long as it's understood when you're petitioning for intervention, this is our interest. We're trying to protect, say, the residential class or some subgroup of residential customers, and this is our concern. And as the case proceeds forward, we will be able to give more detailed information as we receive more information and as the back and forth of testimony goes. So, the type of position that would be possible when is going to be a much more summary one than what might come up later. And very often in the general rate case, this is even more difficult because there are issues that can be raised by other parties who attempt to intervene. And so often there are issues that you had no idea from the original utility application could come about, which I guess would then lead me into the second rulemaking case that we're here for, which is the 0255 case on stipulations. Generally, we have no big concern with the idea of specifying objection. That's already, I think, good practice to be specific, and it's in the interest of someone objecting to a stipulation to be very specific about what it is that is a concern. And I think it's important to remember that sometimes, especially in a general rate case, when there are multiple issues of revenue requirement and rate design, that sometimes issues get pulled in from outside the case. And it's not uncommon for a stipulation that's reached between some parties, a non-unanimous stipulation, to attempt to settle other issues, maybe withdrawing an appeal in some other related commission matter, or to create some new program or something. So sometimes issues will be presented in a stipulation that have never been, that no one had to file written testimony on yet. So that is a concern with some of the things that we saw in the comments of Spire in this case, which would say that would attempt to prohibit someone from objecting to a stipulation if they had not previously had written testimony on it. And that's a real concern if the issue comes up for the first time in the stipulation. I'm sorry, do you have a question?
Just a quick question,
Sure.
Mr. Kaufman, but your concern is about their suggested additions to the rule, not about the actual rule as it currently is written, is that right?
That's right. You mean
Okay.
as proposed by the commission? Right.
Yeah.
Yes.
Okay.
We could live with the rules as proposed by the commission, with kind of the context that I gave earlier. But we do have serious concerns with the two proposals proposed by Spire. We think that those would violate due process and would put some parties on at a severe disadvantage and maybe a catch-22, whereas issues, issues are raised later in the case, maybe in surrebuttal or then in actually the stipulation itself, and we would not have time to put written testimony in. We often have limits on our budget, or we would even have expert witnesses. But if a rule was put in place that you had to have raised an issue in written testimony, otherwise you couldn't even object at the hearing or regarding a stipulation, it would put us in the situation of considering having to have witnesses objecting to everything in order to preserve our opportunity to be able to have our day in court at the end of the case. So I don't think that there has been a problem in the years that I've litigated the commission whereby the commission, if it has a non-unanimous stipulation and then some parties who are not, those parties can then just pull out the issues that they have a concern with and have a full hearing on it. And again, I think it's important to understand that a litigant has the opportunity to try to make their case on cross-examination, not just with direct testimony. That's difficult, and it's rarely successful, but it is a legal right, a due process right, that I feel like we would have to try to poke holes in someone else's case and to try to show what we think might be a better position on cross-examining a witness who has raised an issue, not necessarily having to pay for an expert witness ourselves. And I can recall some cases, and this was a long time ago, a case where there was a renewable energy program that in our opinion we thought was kind of a scam, and we didn't have anyone to be an expert witness on that, but we were allowed the opportunity to cross-examine and point out weaknesses in that proposal, and would hope that the commission would respect our right to be able to do that if we felt it necessary in the case. So I think there might be other concerns that we could raise, and I'm interested to hear what Spire has to say in support of its particular issues. But we were rather alarmed by what we saw in their comments. As first as saying that you would have to have had written testimony or else not even be allowed to object to a stipulation, and also their proposal that when a stipulation was being considered, that the commission would somehow by rule be required to give that more weight than someone else who had a differing opinion. It seems like the commission should be able to weigh that information for itself, and if that's the way the commission feels, that's fine, but not to have some sort of a burden of proof switch written into the rule itself. I don't know if that would help the commission process things any quicker, but it certainly does feel like we would be become a third-class citizen as far as our due process rights go. So would hope that you keep that in mind, and I guess that's all I have as far as introductory. I would reserve the right to maybe comment on anything else that comes up that I haven't heard about yet.
Would any of the commissioners have any other questions for Mr. Kaufman? I'm not hearing any, so thank you, Mr. Kaufman. Mr. Opitz, would you like to go next?
May it please the commission. Tim Opitz on behalf of the Midwest Energy Consumers Group. Just as a preliminary matter, I'm going to state my comments, but I did type them up. I can offer them to you now, or if you'd prefer, I can file them in the docket if that's acceptable.
I can take them
Okay.
now.
May I approach?
Sure. And I'll just, for ease of putting them in EFS later, I'll mark these each as Exhibit 1 in their respective cases.
Thank you, Your Honor. I'll start off with the intervention docket. Just as an overview, MECG does not have any strong concerns about the rule as put forward in the register. It's our view that while it may require us to update our intervention pleadings, we would be able to accomplish that. Now, upon reviewing some of the comments of the other parties who filed them, my comments are essentially replying. So replying to OPC, I would say MECG notes our support of the OPC's comments on the intervention docket. I think that the issues they raise do raise a concern that there might be a greater benefit to exploring what the commission is trying to accomplish with this rule or what they intend to accomplish with this rule. And I think that there'd be a good opportunity because as is, I think there's still some ambiguity with what would be required in the filing under the new rule. Replying to the Division of Energy, they filed comments. I have no issue with that, but I think it, again, substantiates the OPC's concern that this seemingly innocuous rule may have unintended consequences. Replying to Spire, their pre-filed comments say they believe it will avoid unnecessary delays from parties intervening and then determining their interest in a case, and that that will provide all parties an instance where the issues Spire asserts exist or would be remedied, information needed to resolve the case in a timely manner. I'm not aware of any instance where the concerns raised by Spire have come up. Again, I would say that reflects on the advantage of OPC's suggestion that we discussed this morning working docket. If Spire does have real concerns, happy to hear them and work on addressing them. And then Consumers Counsel, responding to them, his comments generally align with those of OPC and MECG that, this is a rule. We could comply with it if the language as filed went forward. But I think that there is some advantage to talking about it and getting more specificity on the rule. So those are my comments on intervention. Are there any questions on that before I move to the stipulation and agreement rule?
Do any of the commissioners have any questions about that?
So on the stipulation agreement rule, again, as filed, MECG would comply, not really an issue. Again, upon reviewing the pre-filed comments in this case, those of OPC seem reasonable and make sense, so MECG would support the OPC's suggested edits to that rule. In reply to Spire, Missouri, I share many of the concerns raised by Consumers Counsel. The company there invites the commission to pretty dramatically change its case procedures with the addition of this new language that they're proposing. Now, I understand that's not the rule, but I want to lend my support to opposing what Spire is proposing here. They kind of raise 2 points. First, that parties are required to file testimony before asserting positions or having an ability to weigh in on stipulations. And second, they suggest that stipulations that are non-unanimous, that have a majority or maybe certain favored parties, be given deference. A couple concerns I have is first, their suggestions are contrary to fundamental tenets of commission practice and rules of evidence. The first thing I'd point out is whether a non-unanimous stipulation is filed, the burden of proof rests on the party asserting the affirmative of that issue. One case talking about that is Ag Processing v. KCPL from 2012. We see this principle in instances where there is a unanimous stipulation and the commission requires an on-the-record proceeding for parties to talk about it. So it seems counterintuitive that you would adopt a rule that says, well, for non-unanimous, we're going to give them even greater deference than we do to unanimous. I think that's an inappropriate burden shift. Second, the suggestion that parties must have pre-filed testimony before objecting, I think violates the rights of parties to cases. There's another case, Black v. State, talks about the right to cross-examination is essential and indispensable. The right to cross-examine who has testified for the adverse party is absolute, not a mere privilege. I think Consumer Counsel also referenced a case, it might have been Fisher, that is specific to the Public Service Commission, although a little bit older. When a party objects, the signatories can adopt that as a joint position statement, but they still have that burden to prove the underlying facts supporting that stipulation. And I think parties should have a right to cross-examine the proponents of those stipulations should they object to certain provisions within it. Third, as a practical matter, Spire's statements that its revisions encourage settlement are just wrong. If anything, its suggestions create a perverse incentive for parties to game negotiations by talking with certain favored parties to the exclusion of others. I think that's counterproductive. Moreover, to the extent that the commission wants to favor settlement as a means of administrative expediency, I think that is a factor that should be considered. But ultimately, when the commission is setting just and reasonable rates should take the priority over, administrative expediency. And fourth, setting aside the legal burdens and the rights I just mentioned, Spire's standard of greater deference that they included in the second part of their comments is undefined, and it's my view that it would simply create additional controversy. And then lastly, so I would urge the commission to reject Spire's comments in their entirety. And lastly, replying to Consumers Council, they don't object to the underlying amendment, which I think is fair, and they oppose the revisions by Spire. I agree with Consumer Council that the Spire's comments should be rejected. As I was looking at my comment here, I did, if with your permission, go back to the intervention rule. Consumer Council mentioned that the Missouri Commission has a pretty short intervention deadline, and sometimes that can be difficult for parties who have to get permission from a board, or supporting companies to intervene in time. That can be difficult, and I do want to note that other Midwestern states do have more relaxed intervention deadlines than Missouri. As just one example, Kansas, they allow intervention until right up to the hearing, and then in a recent case, they actually allowed intervention even after the rates have gone into effect. So, I would encourage the commission to continue to be permissive in terms of allowing intervention. I think it builds a better case, and I don't necessarily endorse allowing in every instance, intervention after the hearing, but, I think that with the mindset of adjusting as circumstances are presented should be kept in mind. So with that, happy to answer any questions.
Thank you. Are there any commission questions for Mr. Obitz? All right.
Thank you.
Now I'm just going to kind of go through the room, and then we'll get to the people online. Mr. Kleiser?
I'm sorry, when you first started off, I was a bit confused, so the OPC does have comments. Okay.
Yes, I understand. Would you like to give those comments now, or I was going to kind of come back to you at the...
If that's the case, then I'll just wait. I apologize, I just want to make sure.
All right, we won't forget you. Are there comments? Do you all have comments?
Hello, Judge and Chair. Scott Weitzel with Spire. I'm the Vice President of Regulatory and Government Affairs. Weitzel, W-E-I-T-Z-E-L. No problem. We'll first start with the intervention. Got documents here so I could keep all my numbers straight. Spire appreciates the effort the commission staff have taken to amend this regulation regarding intervention. Spire is in support of the amendment to 20 CSR 42402-075. That's really all I have on intervention. Second item is the stipulations and agreement. Again, Spire appreciates the efforts the commission and staff have taken to amend and stipulations and agreement. Spire is in support of the amendment to 20 CSR 4240-2.115. There's been some comments about what Spire filed, and just wanted to educate and level set for the group on why we approach those potential additions or things for consideration. We have seen in cases where folks and intervening parties do not identify any issue through a procedural schedule. There's no testimony. There's no witnesses. And when we get to an end of a case, there might be a specific issue that parties want to address. And at the same time, we're trying to work on a global stipulation. And sometimes those specific issues, and, the issue that I'm talking about, no party in this room, did this tact. It was others, but they were in the case for one specific tariff. And they wanted to use that leverage to derail a global stipulation with the other parties. So simply, what Spire is trying to say is, if you're going to object to a stipulation agreement, that's why we're in support of the commission's agreement, is you got to specify. Why are you objecting to this? Because we would have liked to see that back then, but it's holding up progress in a case, it's holding up stipulations and agreement as potential hostage for a specific issue. We just would like folks to be engaged on the front end, state their position through procedural schedule, through testimony, have witnesses, and instead of at the last hour, potentially objecting. But, that could have been just a situation many years ago. Again, none of the folks in this room were that party or parties, but we've seen it in the past. But at least we're confident and support what the commission has put forth with stipulations agreement, and think that's progress towards resolving that issue. Those are the comments Spire has. Thank you for your time, Chair and Judge.
Are there any other commissioner questions? Thank you, sir. Mr. Fisher, did you have comments?
Briefly, Judge. For the record, my name's Jim Fisher. My law firm is Fisher and Doherty PC, and our address is 2081 Honeysuckle Lane, Jefferson City, Missouri, 65109. Thank you very much for the opportunity to be here today. I'm here representing the Evergy companies, Evergy Missouri Metro and Evergy Missouri West. Evergy doesn't have any objections to the Commission's proposed intervention rules. However, we did want to just raise very briefly for your consideration a policy issue related to interventions. For years, the Commission granted liberal intervention to all parties, including public utilities that desired to participate in their sister public utility cases. This promoted the public interest and ensured a complete record on the issues that could directly impact those utilities that were participating. In more recent times, we've observed a tendency to be a little bit more reluctant to allow such interventions, and I just wanted to discuss an issue or two related to that. The PSC tends to decide cases as consistently as they can based on the records that are in front of them. And as a result of that, a public utility may have a decision made in a previous case involving another utility that will directly affect them. And whenever it gets to their case, while there's no stare decisis that requires that it be decided that way, most of the time the Commission does tend to answer the question in a consistent way. We've seen that happen in, for example, fuel adjustment clause cases where you're talking about sharing mechanisms, or perhaps MIA cases, or perhaps rate case expense issues, or other rate case issues. Whenever a utility issue is raised and decided, then that often is the way it's decided in the second and third case. We think it would be helpful for the Commission to consider that fact as it's looking at interventions by public utilities in their sister company cases. We recently saw that in that data collection case that I think the chair is familiar with, where the Ameren and Liberty asked to intervene in our case, the Evergy case, because it involved industry-wide issues, but they were denied. And then in the hearing, there were questions raised about what what did Ameren do and what did Liberty do related to data collection or creation of data? And they weren't there to answer those questions directly, and we think it would have been helpful to have someone there to clarify or correct the record on those topics. With that, I'll just say I'll be happy to answer your questions and encourage you to have a liberal intervention policy related to public utilities.
Are there any questions for Mr. Fisher?
Thank you.
All right. Mr. Owen, would you like to make comments?
I would, Your Honor. If it may please the commission. My name is James Owen, O-W-E-N, no S. I am the Executive Director of Renew Missouri. We are here today to speak in regards to the proposed rules in a general sense, as well as the responses from the other parties, required interveners, interveners that are optionally involved with these cases. To begin, to speak on both matters, on both proposals, we don't see anything with this language that presents itself as concerning to us. However, to reiterate what the Office of Public Counsel has said, without workshops, without being able to talk to the other parties, it's hard to know exactly what the purpose is for these changes. We hear concerns, we hear issues from some of the other parties that are here, but ultimately, if the question is whether or not the rate case process or the process of approving projects, revenue, et cetera, is a matter of efficiency or effectiveness, one of the arguments that we would make is, and I speak to this not only as a clean energy advocate, but someone who has also been a consumer advocate in the past as a former public counsel, is to ask what the purpose of the rate case process is, of what the regulatory process here is. As monopolies, the inclination to work without free market concepts and principles requires there to be some sort of synthetic effort to slow the process down, to make sure consumers are protected, to make sure decisions are made in a deliberative process. I believe any rule or change that affects that could have consequences that we're not aware of sitting here today or contemplating today. So I would just say, in that regard, we would ask that they have some more discussion, some more collaboration with the parties before we move forward with any changes. That would be one of the things that we would urge the commission to do, and we would reiterate what the Office of Public Counsel has said. We also want to reiterate in regards to the intervention rule, the initial intervention rule, that we would echo what has been already said by Consumer Counsel, by MECG. We'd also ask to reiterate what Mr. Fisher has said, that we would like there to be liberal rules for every intervener, not just utilities, because we believe that the more voices and the more people that are here are important and necessary. While we don't see any issue with the language as it's written now, interpretations of that could have consequences we're not aware of. In regards to the objections and the stipulations and agreements, again, we would reiterate that we support the comments of Consumer Counsel, of MECG. Also would note in regards to, whether or not a party has a witness or things on the record, it's critical from a smaller intervener, someone who does not have the budget that some other of the interveners here have. Sometimes we rely on other parties to have expert witnesses involved with these cases, that we might agree with them. I mean, we reiterate what they are saying on the record. And just the fact that we don't have an expert witness or we don't have someone speaking to that is a strategic decision. And so to be able to say, based on requiring that as Spire's rules proposals would, that would create inefficiencies and make it harder for smaller interveners to be involved with this. Moreover, it might require us just to simply have to have an expert witness to object to everything, which then I think exasperates this problem that seemingly is wanting to be solved here. So again, we would ask for us to continue having a liberal policy for all interveners when it comes to stipulations and agreements. I think that, if Spire, based on their comments, has said that it's a party that is not involved here, that is not a part of this rulemaking or conversation, is the problem they're trying to address, I would ask, is it necessary when there are a lot of good actors acting in good faith that are here, that are trying to represent the interests that they represent, and that we have to face a potential more strict rule because of one party acting in bad faith, or maybe not doing what they should be doing, or not operating within what the intentions of the law here is, why we should all have to have consequences as a result. And with that, I would open for any questions from the commission.
Would there be any questions for this commenter? All right.
Thank you.
Mr. Owen. All right. Mr. Dandamoody, did you have comments? All right. I can't see who's behind Mr. Fisher. Is there anyone else in the gallery who wished to comment? All right. Mr. Kleiser, do you want to go ahead now, or do you want to wait till we have the others?
Yes, I'll go now. For the record, John Kleiser, C-L-I-Z-E-R. My contact information is with the court reporter, and I'm representing the Missouri Office of the Public Counsel. And I do want to say at the beginning, we're not steadfastly against either of these amendments. Your initial confusion, I just got slightly confused and felt like this was the more fair way to say it because we have raised some concerns with both of them. So I apologize. It wasn't my intention to screw up the order there. But to start, I would like to thank the Commission for taking the time to hear our comments. I'm going to start with the intervention rule amendment. That'd be 0256. And again, at the offset, I'd like to echo what has kind of been said by several other people about we at the OPC believe that there is a good reason to have a very open intervention policy. The Commission, we believe, exists to promote the public interest, and the easiest way to determine what the public interest is going to be to solicit feedback from as much of the public at large as possible. And it also helps to ensure that there's a robust evidentiary record as well as protection for due process rights. So as a general matter, again, the OPC supports a liberal and open intervention policy. With that in mind, the OPC has some concerns with the amendment that has been put forward, in that we think it will make it marginally more difficult to intervene. That fact alone doesn't necessarily mean it's a bad amendment. For example, there could be a major problem that we're trying to overcome that could make it justified to make it marginally more difficult to intervene. But the OPC, we're not entirely obvious to us what exactly the problem that we're trying to overcome is. Instead, it appears the amendment has not been or has not considered some of the procedural realities that come with practice in front of the Commission. And we've already kind of heard some of those comments today. For example, whenever you have a large rate case, you're going to usually have a large amount of information put onto the record in one go, and then the company, potential interveners have a very narrow relative window to actually intervene, so they might not have time to kind of review all of the information that's been put forward, which may make it difficult for them to take a position when they very first file. However, I think the bigger issue is that there are a number of interveners that regularly show up before this Commission. They're usually very large customers, and they intervene because they have an important stake in a company, but then don't normally actually take a specific position in a case. So I'm going to give you a specific example just to kind of prove what I'm talking about. Nucor Steel of Sedalia it's a big metal company in Sedalia, Missouri. They're a huge electric consumer because they run smelters that run nearly constantly, so they're constantly smelting, and they're served by Evergy West. Now, Nucor Steel is going to routinely intervene in Evergy West rate cases because they have a stake. They are a big taker of energy. They actually have operate under a special tariff called the SIL tariff. And in fact, in this current Evergy West rate case, for example, Nucor Steel has intervened and has been granted intervention. But the thing is, Nucor also, for various reasons, will very rarely need to take an active position in the case because its SIL tariff is very rarely going to become an issue in the case. It still wants to intervene to protect its interests, but it doesn't necessarily have a position going forward. And that's what it states in its intervention. And it's that kind of case that, is what we're most concerned about. I'll give you a second example, again, just to show you what I'm talking about. Triumph Foods, LLC, will sometimes intervene in Missouri American Water cases. Again, they're a large consumer of the utility service being provided. In the last Missouri American Water case, for example, Triumph Foods intervened. And when they intervened, they didn't state, we have a position, but then they later had to file rebuttal testimony to address issues that had been raised by staff. So these are the kind of cases that we're talking about when we say there's a good reason that somebody might need to intervene but not stake a position because they're protecting their interest, and they don't know if there's going to be, they don't even know if their interest is going to become an issue in the case. And that's our biggest concern, really, with the intervention rule as it's been put forward. In our comments, we suggested that you can use a workshop. I know that workshops can sometimes run into problems before our commission. They have a tendency to kind of devolve into a limbo and get lost. I've been party to many such workshops. A very brief digression, I would offer, if the commission wants a way to solve that, I would throw out two things that I think you can do to kind of fix the workshop problem. The first is that when you start a workshop, you either need to set a timetable or order your staff to basically produce a timetable, much like a procedural schedule in a normal rate case. And then the other thing is, the end goal of each of those workshops should be to file a final recommendation, probably by your staff again. That kind of finality will help you close out the workshops, which when combined with having a definite timetable should make those a much easier process and much less likely to getting lost in regulatory limbo. So those are my comments on the intervention rule. I'm going to skip over now to the stipulation rule. As we stated in our initial written comments, we have much less concern here. I agree with what I think most of parties have said, that being specific with what provision is being objected to isn't a problem. Like, we should be able to identify we object to provision 1A of the stipulation, for example. Our concern mostly comes down to the idea of needing to provide specificity for the reasons. And really, it's just a matter of how is the commission going to understand that term in application. And our biggest concern is the fact that a lot of the stipulations that appear before you are very bereft of details, right? We use a lot of black box settlements that come in and they have very little information in them. So how much specificity do you need to have to object to something that doesn't have much specificity to begin with? That's our concern. I think that if you remove that with specificity language and what's been proposed, that completely removes that issue. So I would suggest with that change, the OPC doesn't have a concern with the objection language. I want to very briefly touch on the proposals that have been mentioned regarding what Spire has put forward in comments. I do understand where Spire is coming from. I think I know particularly which company they're actually referring to even. But we also have concerns with what Spire has proposed, and I don't think they would work. First of all, with regard to the issue of requiring you to have testimony in order to object, statute, specifically section 536.070, requires that for administrative proceedings, parties be able to cross-examine witnesses, including on matters for which there was no direct testimony or direct examination. And the commission's under statute 386.125 is bound to the Administrative Procedures Act 536 when it passes its rules. It is my belief that it would be a violation of the statute to do what Spire is proposing, because you would be locking off the ability to cross-examine witnesses if you didn't have your own direct testimony. So again, I understand where they're coming from, but I don't think that what they're proposing is legally sound. As for the other proposal, which is to give greater deference to non-unanimous stipulations, as long as a majority of the parties, including the company and the staff, are in agreement, I don't think that this is constitutionally sound. First of all, we're not entirely sure what greater deference means here. It sounds like it's trying to create an evidentiary presumption. If that's the case, it threatens due process if there's no clear rational basis between what's being presumed and why. And I also don't understand why exactly the company would need to be a part of the stipulation in order for it to work. Honestly, to me, kind of seems like blatant company favoritism. But if you remove that, you also immediately see the problem, right? Like if we just said, as long as the majority of the stipulation, majority of the parties are in the stipulation, then it gets greater deference. Like, let's imagine if that were to happen. You can easily think of a case where you have OPC, staff, and let's say 2 or 3 other parties, MECG, for example, maybe Renew Missouri. We all sign a stipulation that says we think the return on equity should be 6%. Well, the company's asking for 10%. Well, if that 6% were given greater deference because there were more of us than there was of the company would probably be screaming bloody murder. And frankly, I think that they would have a reason to. Like, that would make sense. So for that reason, I just don't think that that's a very reasonable change, and I would strongly suggest that the commission not adopt either changes proposed by Spire, Missouri, although I do respect where they're coming from. So those, I think, are the conclusion. Again, just to summarize, for the intervention one, we recommend not moving forward at this time, opening a workshop, trying to figure out what the problem is and solve that problem while also still allowing companies like Nucor, like Triumph, and others to intervene without having to take a position. And then for the stipulation one, if you remove that with specificity language, I think that we don't have any other concerns with it, but I would not propose adopting either of the changes offered by Spire, Missouri for the reasons I've stated. And those are my comments. Thank you very much.
Thank you. Are there any commission questions? I don't see any. Thank you. Okay, I know we have several people online that were wishing to speak. I know Ms. Plesha is online and had comments. Would you like to go ahead?
Yes, I would. Thank you, Judge Dippell. Diana Plesha for the Missouri Industrial Energy Consumers. I share the concerns that were very well stated by all of the parties that have actually gone before. We have serious concerns about the comments raised by Spire regarding simple due process issues with respect to stipulations and agreements as expressed by Mr. Kleiser. Regarding intervention, that is a special issue for industrial consumers, I think. You have interveners, for example, like the Office of Public Counsel, or excuse me, the Consumers Council of Missouri, or the MECG, who have to develop their positions after consultation with clients, after review of voluminous data that the utility will put forward in a typical filing. And we're reacting to that, and we want to take responsible positions, but it takes sometimes months for consumer parties to develop specific positions in a case. And for my clients in particular, for example, not special contract clients, but just large industrial consumers, in our association, we don't have an unlimited number. We have identifiable companies who participate, and each of those companies needs to review the utilities filing, consider it, develop expert consultation and opinions so we can take responsible positions. And that's part of a process that works at the PSC very well, that we are able to develop our positions as we go. I think that I don't see a reason for certainly what Spire is requesting, and I think it's important for the commission to recognize that interveners are reacting generally to the filing by the utility and need to be given the flexibility to reserve the right to state a position or not to be able to state a specific position at an early stage of the case. And so I'd be glad to take any questions from the commission on this.
Are there any commission questions? I don't see any. Thank you, Ms. Plesha.
Thank you.
Okay, and I'm not able to actually see who else is online, so I'll just have you speak up if you'd like to comment, and we'll sort it out from there.
This is Bruce Morrison. I'd love to make a comment, please.
Go ahead, Mr. Morrison.
Thank you. I'm a lawyer at Great Rivers Environmental Law Center in St. Louis. Clients before the Public Service Commission have included the Missouri NAACP, Dutchtown South Community Corporation, Metropolitan Congregations United, Homes for All, and a few others. We oppose the proposed change to the rule on intervention because it imposes an unintended barrier to intervention. In my experience, these public interest organizations need the time afforded under the current rule to take a position, to formulate a position. It seems like they've needed every last hour, in fact. These organizations are not unlike many other nonprofits. They are focused on several issues, one of which is energy burden and environmental justice. And the work done within these organizations is largely done by volunteers. Unlike for-profit organizations and unlike the regulated entities that appear before this commission often, there are not people who are paid to stay apprised of matters that come before this commission. These organizations also are not flush with resources, neither with people nor funding. And they need the time afforded under the current rule to assemble people to evaluate an issue and to collaborate with others outside of their organizations before they formulate a position. So I don't want to say it's not feasible, I'm going to settle on it. It's just not practicable to come up with a formulated position when moving to intervene. More time is needed. One last point, please. And that is that the people doing the work in these matters are not the decision makers on the positions to be taken. That usually requires a vote of the body of these organizations or of an executive committee that meets only periodically. For that reason, also asking these organizations to articulate a position at the time of intervention is not practicable. So wrapping up, deliberate informed engagement takes time. And for that reason, we ask that the commission keep the current rule on intervention without making any changes. Thank you for the time, and I'm happy to take any questions.
Thank you. Could you spell your name for the court reporter?
First name Bruce, B-R-U-C-E, and last name Morrison, M-O-R-R-I-S-O-N.
Thank you. I wanted to make sure we got that. Are there any commission questions for Mr. Morrison? All right. Thank you, sir. I can see someone raising their hand, and I just can't read your name, so if you go ahead.
Yes, hi, this is Dana Gray. I'm the Community Development Outreach Coordinator for Tower Grove Community Development Corporation. We're an affordable housing provider in St. Louis. And I wanted to echo in support the testimony that has already been shared just now by Bruce Morrison of the Great Rivers Environmental Law Center, James Owen of Renew Missouri, and John Kaufman of Missouri Consumers Council. I have intervened in PSC cases numerous times in the past. I am not an energy expert, and it takes time for me to understand what the proceedings are involving and to prepare my testimony. And so I just ask the commission that any changes that make it more challenging for us to intervene, those that are representing vulnerable communities, that not be allowed. It would be interfering with our ability to participate. And so I hope you will give that consideration, and I'm happy to take any questions.
Thank you. Are there any commissioner questions for this commenter? I don't see any. Thank you, Ms. Gray. Are there other people online that wish to comment? Mr. Jarrett, did you wish to comment?
Yes, Judge, good morning. This is Terry Jarrett. I'm from Healy Law Offices, appearing on behalf of the Missouri School Boards Association today. My address is 306 Monroe Street, Jefferson City, Missouri, 65101. And I would just like to comment that MSBA supports the comments made today and in the filings of Consumers Council, MECG, OPC, Renew Missouri, and Jim Fisher from Evergy regarding some of the concerns with both the stipulations and interventions changes. Particularly, I did want to mention what Mr. Owen and Mr. Fisher talked about with regard to liberality of interventions. That is very important. I can say from my experience in practicing before the commission, I have had more than one occasion where the intervention deadline has passed and an issue will come up in the case that wasn't there at the beginning. And my client may have been effectively shut out from intervening because it was too late to do so. With that, those are the comments of MSBA, and I'll take any questions.
Are there any commissioner questions for Mr. Jarrett? Not hearing any. Thank you.
Thank you.
Is there anyone else online that wishes to comment?
Yes, Judge Dippell.
Oh, Ms. Whipple, go ahead.
Yes, thank you kindly. This is Peggy Whipple, WHIPPLE, also of Healy Law Offices, 3010 East Battlefield, Suite A, Springfield, Missouri, 65804. And I do appear today on behalf of the Missouri Electric Commission. Its members are 72 municipalities in the state of Missouri, serving over 350,000 Missourians. And today, in both of these dockets, both the intervention rulemaking and the stipulation and agreement rulemaking, MEC joins in the comments of the Office of Public Counsel, MECG, Consumers Council, Renew Missouri, and Evergy. We also stand ready if the commission does decide that it wishes to handle this through a workshop. We stand ready to assist with that in any way that the commission desires. And I am here to answer any questions that the commissioners or you, Your Honor, might have of MEC.
Are there any questions for Ms. Whipple? Not hearing any. Thank you, Ms. Whipple.
Thank you, Judge.
Is there anyone else online that wishes to comment? All right, I'm not hearing any other comments online. Would staff like to make comments?
Good morning, Scott Stacey with Staff Counsel, 200 Madison Street. May it please the Commission. Staff agrees with the changes to the in OX 2024-255 and 256. The Commission is allowed by statute in 386.410 to allowed by statute to adopt rules for hearings and et cetera. And the like, and it may set limits for hearings. Staff has reviewed the comments submitted and the ones we've heard here today. Staff does not agree with the comments or the suggestions submitted by Spire, but we do agree with the way the changes have been made, and the staff does not see where it actually limits anybody from intervention or intervening in the case. It just gives a little bit more explanation as to why you want to intervene. That's all it's asking. It's not preventing anybody from intervening. And the stipulation in 255, the objecting party shall state with specificity the basis for the objection. it's only asking for, give us the basis or your objection. Why are you objecting? It's not asking for any more than that, and that's staff's position. These provide for more specifics to objections to agreements and interventions into the case. Neither of the changes prevent any party from objecting or intervening into the case, but to make it clearer on what the parties' intentions are. And staff does not believe a workshop is required in this case because we believe that the changes that have been imposed here or proposed are clear as they are currently written. Thank you. Any questions?
Are there any questions for staff? Not seeing any. Thank you.
All right, thank you.
And was there any response comments that anyone wished to make? I'll ask in the room first. And online. And did everyone that wanted to comment get a chance to do so? All right. Are there any closing remarks from any of the commissioners? Chair Hahn?
Thank you, Judge Dippell. Good morning. I just want to offer a few points, but most of all, I want to thank all of you for taking time out of your Tuesday to provide these meaningful comments. As you can tell, the Commission is amending these rules because of some of the concerns that have been raised in cases over parties intervening and not stating any position, and then in the end, also not stating any position in a stipulation agreement and opposing it and forcing a hearing, which is costly and for the parties that have worked on the case for the entire duration, unfair to those parties. So that's the genesis behind the rules. I had heard comments earlier that this perhaps is part of improving our rate case process. That's not the case. This is part of making it better for all parties and making it fair for all parties. Today, what I heard from what I think I heard from feedback was that with some modifications, the stipulations and agreement rule is largely agreed upon. I think there's concern over the intervention rule and the idea that we should talk about it in a workshop. But what I didn't hear was that it would prevent any party from actually intervening. It actually doesn't do that at all. It only says you can assert a position or you can wait to assert a position until you can figure out what your position may or may not be. So I appreciate the workshop idea, but I've been here a year now, and what I've witnessed is that rules go to workshop to never come out. And these are fairly simple rules, and where they are fairly simple changes and can significantly improve the process in a fairly short time, I'm inclined to want to move forward with just the formal rulemaking process as every other state agency does in this state without the workshop process. So with that, I'm thankful for your time. I'm thankful for the written comments. It is helpful for me to understand your concerns or where your comments might be coming from. That helps us make better decisions. So I'm thankful for hearing this morning and appreciate all the work that's gone into this. Thank you so much.
Thank you. Are there any other commissioner questions or comments, rather?
Yes, Judge, this is Commissioner Kochmeyer.
Go ahead, Commissioner.
Yes, good morning to everyone, and thank you for everyone's comments here today. I want to echo the chairman's, what she just had to say about this whole process. And here again, I just wanted to thank everybody for attending today. Thanks.
Thank you, Commissioner. Any other commissioner comments? All right, I'm not hearing any. Well, I will also echo the thanks from the commissioners. We appreciate the participation in the process. And with that, we can conclude this hearing and go off the record. Thank you.